Welcome to the Deep Dive, your shortcut to getting informed. Today, we're really strapping in for something quite dense but absolutely critical.
We are.
We're looking at the legal bedrock of nuclear regulation in South Africa. The National Nuclear Regulator Act 47 of 1999.
That's the one.
And look, this isn't just, dusty old law. This is the framework that decides who's responsible, who gets protected, and crucially, who foots the bill when things go wrong with atomic energy.
Yeah, and we're diving into a consolidated version here, which includes some really important updates, some actually as recent as June 2025.
Right.
So whether you're maybe cramming for a law exam or you're just, intensely curious about how radiation safety is legally managed, our mission today is to pull out the key pieces.
Okay.
We'll look at the structure, how the National Nuclear Regulator itself is set up, its powers, the huge range of activities it oversees, and the really practical stuff, liability, emergency planning.
Okay, let's start unpacking that. The Act, it clearly aims to set up this regulator, the NNR, give it teeth to enforce safety standards. But what is the NNR, legally speaking?
Well, legally, it's established as a juristic person.
Okay, like a company almost.
Sort of, yeah. Think of it as an official body that exists independently. It can own things, make contracts, and really importantly, it can sue and be sued in its own name.
Right.
It essentially inherited everything, the assets, the rights, the liabilities from the old Council for Nuclear Safety.
I see.
And it's also listed under the Public Finance Management Act, Schedule 3A, public entity. That means specific rules about how it handles public money.
So it's powerful, financially watched, and independent. What's its core mandate then? What's job number one?
Section 5 spells out its core objectives pretty clearly. First up, protect people, property, and the environment from harmful radiation. That's the big one.
By doing what?
Mainly by setting safety and security standards. Second, they control specific activities, and we'll get into just how broad that is by issuing formal authorizations. You need their permission.
Okay.
Third, they enforce those authorizations, make sure people stick to the rules, and then there are the bigger picture things. Fourth, meeting South Africa's international treaty obligations on nuclear safety.
Right, the global standards.
Exactly. And fifth, ensuring that solid emergency preparedness and response plans are actually ready to go if needed.
That's the strategy. But what about the day-to-day? What tools does the NNR use to make all that happen? Setting standards is one thing, enforcing them is another.
Yeah, good point. Their functions are quite varied. Operational advisory and record-keeping. Operationally, they're the ones granting, changing, suspending, or even revoking those authorizations we mentioned.
Okay.
They also act as the national authority for things like the transport of radioactive materials, following IAEA rules. That's the International Atomic Energy Agency.
Right.
But maybe one of the most critical long-term functions is record-keeping. They have to set up and maintain two key things. A national dose register.
What's that exactly?
It's a central record of radiation doses received by individuals, occupationally usually. And second, a national register of radiation sources. Where is all the radioactive stuff?
Wow. So they track both the risk potential, the sources, and the actual exposure, consequence the doses for decades.
Precisely. It allows for long-term health monitoring and accountability.
That dose register.
Oh.
That's fascinating. Okay, let's shift gears slightly. The scope. What actually falls under the NNR's control? How wide is this regulatory netcast?
It's often described as cradle to grave for any nuclear facility, meaning they regulate absolutely everything. Evaluating the site before anything is built, the design, manufacturing the components, the actual construction, operation, any periods of extended shutdown, decontamination, decommissioning, right up to the final closure, the whole lifespan.
Okay, that makes sense for, say, a power plant. But I remember seeing some details, the sources that seemed, well, surprising. Does it go beyond the obvious stuff?
Oh, absolutely. And this is where it gets quite interesting, I think. Beyond nuclear facilities and nuclear-powered ships, the Act specifically covers decontaminating and releasing old National Defense Force facilities or equipment so they can be used by civilians.
Like old military bases needing a clean bill of health.
Exactly. But probably the most unexpected part, as you hinted, is the specific mention of regulating the exposure of aircrew to cosmic radiation.
Wait, really? Aircrew. Cosmic rays.
How
does a Nuclear Safety Act end up dealing with pilots and flight attendants flying at 35,000 feet? That seems out there.
It does initially, but it ties back to that core mandate, protecting people from ionizing radiation that could cause harm. At high altitudes, there's less atmospheric shielding from cosmic rays.
Ah, I see the connection now.
So the Act sees this as a right For lower risk stuff, the regulator usually issues a certificate of registration. They can even grant a certificate of exemption if the potential exposure from an activity is considered genuinely negligible, really tiny.
Makes sense.
And there's one more key type. If you manufacture a component part deemed critical for nuclear safety, say a specific valve for a reactor, you need an authorization to manufacture that specific part.
Got it. So tiered permissions. Now, for those big licenses, the nuclear site or vessel ones you mentioned, a public protection element.
Yes, and it's a really important one. Before granting one of these major licenses, the applicant must notify every potentially affected local municipality.
Okay.
And they have to publish the application details in the official gazette and in 2 local newspapers in the area. This gives the public a full 90 days to submit written comments or objections specifically about protection from nuclear or radiological damage.
So transparency and public input are baked in right from the start before shovels hit the ground.
Exactly. It forces accountability early on.
That's crucial. Now, let's pivot to the really sharp end of the legal side. What happens if, despite all the rules and plans, something goes wrong? An accident. Who, legally, takes the financial hit?
This is absolutely vital, and the Act uses the principle of strict liability. This is probably the single most important legal concept to grasp here.
Strict liability. What does that mean in plain English?
It means the holder of a nuclear license, the operator of the facility, is liable for all nuclear damage caused by that facility, period. It doesn't matter if they followed every rule or if they were negligent or not. If the damage originates from their licensed activity, they are liable.
So it's like if you own a dangerous animal and it escapes and causes damage, you're responsible, even if you had a strong cage. You don't get to argue about the cage strength, you just pay.
That's a pretty good analogy, yes. And liability follows the material itself. If radioactive material is being transported between 2 licensed sites, the liability stays with the sender until the receiver formally accepts it and documents that acceptance.
Okay, so the chain of responsibility is clear. But is the liability unlimited?
No, it's not unlimited. The Act states the license holder is liable, but the amount of that liability is capped. The minister determines those limits based on assessments of potential accident consequences.
Right. But if there's a cap, how do we know the money will actually be there to pay claims up to that cap?
That's where financial security comes in. It's mandatory under Section 29. The minister doesn't just set the liability limit, they also dictate the level and type of financial security, like insurance or other guarantees that the license holder must have in place specifically to cover those potential claims.
Okay, so insurance is mandated.
Yes, and there's a key update here too, Section 26A. This requires all authorization holders, not just the big license holders, to prove they have adequate financial resources set aside specifically for the safe rehabilitation and eventual decommissioning of their sites or activities.
So it's not just about accidents, it's about guaranteeing the cleanup costs at the end of life before they even start.
Exactly, trying to avoid situations where a company folds and leaves the state or public with a massive cleanup bill years down the line.
That makes sense. Now, on the compensation side, is there a time limit for people to claim if they suffer damage?
Yes, there's a prescription period, a legal time limit. Under Section 34, an action for compensation for nuclear damage generally can't be started more than 30 years after the date the incident occurred.
30 years. That sounds like a long time, but...
But there's a crucial nuance. If a potential claimant only becomes aware of who the responsible authorization holder is and the facts supporting their claim, during that 30-year period, say 25 years after the event, they then only have 2 years from the date they became aware to actually file their lawsuit.
Okay, so it's 30 years max overall, but potentially only a 2-year window once you realize you have a claim.
Precisely. That distinction between the absolute 30-year cutoff and the 2-year discovery window is really important for anyone potentially affected.
Definitely. And who enforces all this? Who are the NNR's eyes and ears, the muscle on the ground?
That role falls to the inspectors. They're appointed by the NNR's chief executive officer.
And what powers do they have?
They have quite wide-ranging powers, and they're serious. They can enter any place they suspect is a nuclear facility or site where regulated activities are happening. They can seize documents, take samples, conduct investigations.
So full investigation rights.
Yes, and they can issue directives. These can range from ordering specific actions, like requiring the cleanup of a contaminated area, to ordering the immediate stop of any activity they deem non-compliant or unsafe. They can effectively shut down an operation.
Okay, they have real teeth. Let's look at the proactive side now. Safety, handling emergencies, and transparency. What duties does the Act place on the authorization holders if there is an accident or even just a near miss?
If any kind of nuclear or radiation accident happens, the holder has an immediate duty to report it straight to the regulator, no delay.
And then what does the regulator do?
The regulators then steps in to investigate. They define the geographical area affected and the time period during which the radiation risk might exceed safety limits. And critically, they have to compile and maintain a record of everyone who might have been exposed within that defined zone, specifically for potential future compensation claims.
So they map the potential victims right away. What about planning before an incident? Emergency plans.
Absolutely essential. Authorization holders, except for those with the really low-risk exemptions, are required to draw up detailed emergency plans. And these aren't just internal documents.
No.
No, they have to be developed in agreement with the relevant local municipalities and provincial authorities. Community involvement is built in. And very importantly, the authorization holder has to cover all the costs of developing, implementing, and managing that emergency plan.
The operator pays for the community safety net.
Correct. And the regulator's job includes ensuring that the plan is actually effective and capable of protecting the public if the worst happens. And linked directly to that community safety aspect is mandatory transparency. Holders of a main nuclear license, the big facilities, have another specific duty. They must establish a public safety information forum.
A what now?
A public safety information forum. Its specific purpose is to keep local residents informed about nuclear safety issues, radiation matters, and the emergency plans relevant to their area. It's a dedicated channel for communication and building trust.
That seems like a good mechanism to counter potential fear or misinformation. Okay, one last area. Disclosure. What if someone working inside sees a safety problem? Are they protected if they blow the whistle?
The Act tries to balance security and safety here. You can't just disclose information that would compromise the physical security of a facility that's prohibited.
Makes sense.
However, there's strong protection for whistleblowers who reveal information about a genuine health or safety risk. The Act shields them from civil or criminal liability, from being fired or facing any other prejudice.
And provided
they disclose the information in good faith to the right people, high-level bodies like the public protector, the minister responsible for nuclear energy, or the regulator itself. It encourages internal problems to be reported upwards without fear.
Okay, that's a comprehensive overview.
Yeah.
Looking back at this whole complex regulatory structure, what really stands out to you?
For me, it's the absolute clarity around responsibility. The core principle, stated right in the Act, is that the primary responsibility for safety and security rests squarely with the authorization holder, not the government, not the regulator, the operator. That principle, when you combine it with the strict liability for accidents, the mandatory financial security for decommissioning and potential damages, it shows a clear strategy. The state basically says, you want to operate in this high-risk field? Fine. But you bear the financial and operational risk, and we, through the NNR, will watch you like hawks.
So for our listener, whether they're deep in legal studies or just trying to grasp how this powerful industry is managed, what's the main takeaway?
I think the key thing to understand is that this act creates a truly comprehensive, cradle-to-grave regulatory system. It covers everything from designing massive power plants right down to managing cosmic ray exposure for flight crews.
Right. That detail really stuck with me.
Yeah, and it gives the regulators significant enforcement power. It mandates public safety planning, community engagement via those forums, and crucially, it ensures there's a legal framework for financial recourse through strict liability, backed by guaranteed funds. It's designed to be a robust system.
It certainly sounds like it. Okay, here's a final thought for you to chew on. We talked about the 30-year maximum time limit for claiming nuclear damage compensation. But we also know that nuclear waste disposal and potential contamination can have consequences lasting for centuries, far beyond 30 years.
That's true.
So how effectively can the requirement for financial security for decommissioning money set aside now truly guarantee environmental safety and financial protection decades, maybe even centuries, down the line, long after that 30-year legal window for claims is closed? It raises questions about very long-term stewardship, doesn't it?
It really does. It points towards a need for ongoing governmental oversight and potentially long-term trust funds or mechanisms that extend far beyond the typical legal horizons we're used to thinking about. A very pertinent question indeed.